Experienced New York estate probate lawyer. The probate process refers to the transfer of property from a decedent to their heirs. After losing a loved one, having to go through a lengthy and often complicated legal process is the last thing anyone wants to do. The probate process in New York can take months or even years to complete and may involve a lot of hearings and paperwork. Having the help of a skilled attorney can lessen the burden and finalize the process promptly. Top-rated New York estate planning attorneys at Sishodia PLLC explain the NY estate probate process. A will or a last will and testament is a written document detailing what a person wants to be done with their property after they have passed away. A person who has written and executed a last will and testament is referred to as a testator. A will can have directives on property division, whether the deceased wanted their property donated to charity, and guardianship of any minor children. The document also names an executor or fiduciary to carry out the decedent's wishes. Wills should be treated as confidential documents until the person passes away and only become a matter of public record when filed in probate. Wills do not take effect automatically. When a person dies, there are specific legal processes involved to determine whether the document is authentic and whether it has been created in accordance with the law. If the decedent's estate is valued at less than $50,000 and does not include real estate, or the estate is composed of non-probate assets, the probate process would not be necessary. While probate assets can include property such as real estate, automobiles, jewelry, and other heirlooms, non-probate assets in New York include retirement accounts, property held in a trust, bank accounts with specific beneficiaries, jointly owned assets, and life insurance policies. There are also ways to structure an estate plan that allows asset distribution to the beneficiaries without the need for probate. A step-by-step view of the probate process. 1. Filing the petition to initiate the probate process. The assigned executor of the will should file the original of the will and a certified copy of the death certificate together with other documents in the surrogate's court of the county where the decedent lived. A filing fee also needs to be paid, with the value calculated based on the dollar value of the estate. 2. Sending the notice. The executor needs to file a notice informing the decedent's beneficiaries and heirs about the petition. Any creditors with a stake in the estate should also be informed. 3. Taking asset inventory. The executor would have to conduct a full inventory of the decedent's assets and have them appraised to determine the current value. 4. Paying off creditors. Any debt the decedent incurred and had not been paid off completely while they were still alive has to be settled by the estate, including any income or property taxes, mortgage payments, etc. 5. Distributing the remaining assets to beneficiaries. If there are any assets remaining after paying off creditors, the estate's beneficiaries or distributees will be served with a citation. The probate process is governed by the New York Surrogates Court Procedure Act. What happens if a person dies without a will? Dying without a will is legally referred to as dying intestate. Each state has its own process of determining the beneficiaries if a person dies without a will. In New York, instead of undergoing the probate process, an administration proceeding will be held and the court will appoint an administrator for the decedent's estate. While dying intestate still allows the family of the decedent to receive parts of the estate, the way the estate is distributed is completely dependent on New York's intestacy laws. If the decedent does not have family that can be found using genealogy services, their estate will pass to the ownership of the state of New York. Comprehensive estate administration process by top probate attorneys in New York. 1. Preparing and filing petitions for administration, temporary administration. Our first step is to meticulously prepare and file the necessary petitions, whether for administration or temporary administration, ensuring a strong legal foundation from the start. 2. Collecting waivers and consents. We prioritize obtaining waivers and consents from next of kin, expediting the process and avoiding unnecessary delays by promptly filing these crucial documents with the court. 3. Filing citation for court approval. In cases where obtaining waivers is challenging, we take proactive steps by filing citations for court approval, ensuring compliance and legal validity throughout the administration process. 4. Creating a list of assets. Our team carefully creates a comprehensive list of assets belonging to the estate, including real estate, financial accounts, investments, personal property, and more, facilitating transparent asset distribution. 5. Notifying interested parties. We diligently inform all interested parties, including beneficiaries and creditors, ensuring transparency and compliance with legal requirements. 6. Settling debts and taxes. Our attorneys meticulously handle the settlement of outstanding debts and taxes associated with the estate, ensuring compliance and protecting the interests of the estate and beneficiaries. 7. Distributing assets. We distribute assets thoroughly following legal protocols, adhering to the decedent's wishes or applicable laws to ensure a fair and equitable distribution process. 8. Closing estate. We complete the process by formally closing the estate, filing required documentation, resolving remaining matters, and providing you with comprehensive closure and peace of mind. Is there monetary compensation to administrators and executors in New York? In New York, administrators and executors are entitled to reasonable compensation for their services, as determined by the New York Surrogate's Court Procedure Act, SCPA. The fees are calculated on a sliding scale, ensuring fair compensation for the responsibilities undertaken during estate administration. Why should you enlist the help of an experienced attorney for probate or administration? The answer lies in our experience and efficiency. Our attorneys navigate complex legal processes, mitigate risks, ensure compliance with laws, and streamline the administration process, ultimately saving you time, effort, and potential legal complications. How does ancillary probate work in New York? Ancillary probate is a secondary legal process that complements the primary probate proceeding. It is required when a deceased person, the decedent, owned property outside their home state. The primary probate court lacks jurisdiction over such out-of-state assets, necessitating ancillary probate. While ancillary probate commonly deals with real estate, it can encompass other assets like vehicles, boats, aircraft, or rights to resources such as oil, gas, or minerals. Ancillary probate and administration for the deceased who were not domiciled in New York State, but have assets in New York. To ensure a smooth estate process in New York, it's crucial to have either a U.S. citizen or a non-U.S. citizen residing in New York act as the estate representative, such as an executor or administrator. This involves filing a petition with the New York Surrogate's Court and listing the estate assets in the state and the beneficiaries. The petition must include authenticated copies of the will, any probate-related documents, and, if applicable, documents from the foreign jurisdiction. The court reviews these documents and issues ancillary letters testamentary or ancillary letters of administration to the non-domiciliary representative. This person then gathers the estate's assets, settles debts, files tax returns, and prepares for distribution to beneficiaries. Working with a skilled New York probate attorney. Create trusts and wills to protect your assets. Depending on your financial profile and the assets you have, an attorney can use a variety of available estate planning tools to allow your property to be passed on to your beneficiaries with minimal hassle. Assist an executor in the New York Probate Court. A skilled New York probate attorney can assist the executor in their duties and prepare the necessary documents to submit to the court, as well as file the notice to the stakeholders about probate. An experienced lawyer can also guide the executor on how to proceed with their newfound responsibilities such as filing taxes on behalf of the estate, paying income taxes on any trusts, and making sure that the asset distribution proceeds without issues. Get the help of experienced New York estate probate lawyers from Sishodia PLLC today. Probate is a complicated legal process. It is the responsibility of a skilled New York estate probate lawyer to assist in making the process more efficient for everyone involved to allow the decedent's loved ones to move forward with their lives. At Sishodia PLLC, our practice is dedicated to providing quality legal services to our clients. We believe that helping to ensure that a decedent's will is validated and that their estate is distributed to their rightful heirs is a part of honoring the decedent's legacy. Our team of experienced New York estate probate lawyers is here to help. We serve all the 5 boroughs in New York. Call our office today at 833-616-4646 to schedule a free consultation with one of our top-rated lawyers.